Just give a minute. I'm just. Yeah. So welcome to this webinar on. I prefer all of you coming on the camera. I will love it so that I understand. I don't speak with a wall. But tell me, are you able to hear me properly? Only I can see only 6 people putting in chat yes karke or good evening. Just confirm that you are able to hear me properly. Okay, I will proceed now. So welcome to the webinar on probate, letters of administration, or heirship certificate, or succession certificate. End of this webinar, you are going to understand what is succession certificate, what is probate, what is succession certificate, what is probate, what is heirship certificate. Everything you will be understand by end of this webinar. That's what my promise is. I appreciate that 55 people have joined up to now, 56 I can see. It shows that you are anxious to learn something, and so keep it up. So my name is Girish Rao. I'm advocate and solicitor. I have more than 27 years of experience at now present. So I'll be taking you through the provisions of probate, succession certificate, letters of administration, and heirship certificate. So now let's start. All are ready? Say yes. Type करो. कुछ जोश दिखाओ यार तो मजा आएगा. ठीक है? Okay, good, 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 Kiran, good, Natasha, good, Banu, Ketan, Sanjay. Let's start. Okay, let's start. All of you are able to see this, my screen. Okay, all of you are able to see it? Just a minute. Okay. So let's understand how this whole process of probate, letter of succession, letters of administration, or succession certificate starts. So basic, when we start with this, when a person dies, he has either made a will or he has died without making a will. These are the only 2 circumstances. So when he has made a will, his property will have to be distributed as per the direction in the will. Now, when I'm referring to will here, will also includes codicil. So last occasion when I think in October, we conducted one webinar on that. We discussed a lot on the will. So I'm not going to discuss anything on the will now. But will is a basically intention of the person making the testator, making the will. That is what is will is. And other circumstances is a person who has died without making any will. So when a person dies without making any will, then his property will devolve as per the Succession Act, which will be applicable to him. It could be Indian Succession Act, it could be Hindu Succession Act, or it could be if he's a Mohammedan by religion. So it could be the Succession Act which will be applicable. So there are two circumstances, either he has left a will or he has not left a will. So normally when he has left a will, we in legal terminology use the word testate. Or he has died without making a will, we use a word intestate. He died intestate without leaving a will as per his as per XYZ Act, maybe in Hindu Succession Act, these are XYZ people are legal as like that, right? That's how we mention in the document. So is it clear now that the two circumstances, a person has died with will or without making a will? So we'll now understand, try and understand, if he dies with making a will, what is the process which has to be adopted, right? So now, when a person dies making a will, in will, what are the, okay, let's say, when he dies making a will, the will has to probate it. When a person dies, you all are able to see this screen? Yeah. If a person dies making a will, then the will either has to be probated, means you have to obtain a probate, or you have to obtain letters of administration with the will annexed. If so, when there is a will, what are the two circumstances? I'm sorry. Is either you have to make application for probate or letters of administration with will annexed. We'll go deeper into it. If he dies without making a will, then either letters of administration or succession certificate or heirship certificate, these are the three things you have to obtain. So if there is a will, two options, only two options, that is probate and letters of administration. If he dies without making a will, then you have a three options, right? Any questions on this aspect up to now? No questions? I'll proceed further now. So now let's discuss, a person has died making a will. Just a minute. When a person has died making a will, he has to obtain, as I told, a probate. So now question is, what is a probate? Probate is nothing but a certified copy of will. It means the court certifies that this is a copy of will, in the sense that the will has been executed as per the requirement of Indian Succession Act. That is what will has been made, for which there are two witnesses to the will, and it has been drafted properly. Probate does not mean that whatever described in the will is proper or right. May suppose a person, giving an example, a person in a will says XYZ, I hereby give, bequeath is the word which is used, give XYZ building to my son so and so. But if he is a not owner of that building, he can't give that building to him. So what is the content of the will? Court is not concerned with it. Court is only concerned with whether the will has been executed as required under the law. That is, will has been executed by the person whose name is there, and there are two witnesses to the will. Nothing else court is concerned. Court is not concerned what is given, who it is distributed, not distributed. Court is not concerned. So it is just a certified copy of a certificate by the court that the will is executed, not of contents. So you will say by that will he has given me and court is accepted. No, probate does not means that. Is it clear? If it clear, type yes in the chat box. I want active action from you. Otherwise, I will Okay. Okay. Good, Girish. Good, Reshma. Good, Prashant. Good, Shirin. Good, Ketan. Neil. Prathamesh. Padmesh. Prajakta. Admin. I don't understand what is admin. Good, Banu. Thank you. Okay. Why you are putting essays? Deepam. Anandan. Sumi. Thank you. Yes, good. Good, good, Somesh. So that is one part of the will. Now, two things are possible. Letters of administration with the will annexed to it. What happens? Sometimes will contains what? Number one is the person who is signing it. In the will, you are supposed to make one person as an executor. Executor means what? Means you appoint a person who is going to distribute the property which you are written in the will. Suppose he has 4 flats and 4 children. So he will tell X, 1 flat to my elder son, 1 flat to second son. Like that, he is distributing the will in the will. But then who is going to do that job of distribution job? There's nobody. For that purpose, in a will, you appoint one person as an executor. But if you are not appointed any person as an executor, so there is a will which is there, that is existing. Then what you have to do is that you have to make an application for letters of administration with will annexed. That means what? The property of the person who dies, his property will be distributed to the person who he has described in the will. It will be distributed as per what is described in the will. There is a will and there is no executor. Or possibilities are also there. Executor is not ready to act as an executor. He is not taking the step. See, for probate, who it will be granted? Probate will be granted only to the executor. Probate will not be granted to the beneficiary. If executor is not acting, in that case, the beneficiaries or person entitled can make an application for letters of administration with will annexed. Is it clear what is the letters of administration with will annexed? If clear, type clear or type yes in the chat box. If not, you can ask me. I hope Rakesh, you are there. You can just, if someone asks question, let me know. I don't mind intervening and replying those.
Okay, sir.
Beneficiary can be executor. Girish, this is the question which we discussed on this thing, will topic. So we will not go into that now here. He can be. Okay, Bhavesh, I will be coming to those. And don't put direct question, rather put on the group so that everyone understands. What is the basic difference while acting upon? I don't understand the question, Yogesh. Okay. I have not understood a Yogesh question. You can ask again more clearly, or we'll open it for you to speak. So there are two options when there is a will. One is probate and another is letters of administration with will annexed. So now let's go to the second question, second part, where a person has died without making a will. Other thing which I wanted to say is that probate is mandatorily required. It's a mandatory if the person who made a will, it is made within the jurisdiction of Bombay or Madras. Section 57 of the Indian Succession Act deals with it. Or it is in respect of any immovable property within the jurisdiction of Mumbai or Madras. If it is in Thana, if it is in Pune, will probate is not something which is mandatory. But if it is in Bombay, then it is mandatory. So you will often hear that word. It's in Bombay, so probate is necessary. Why? Because of section 57 of the Indian Succession Act. I am not going into detail of that act, section 57. I already put the Indian Succession Act on the group. You can check up over there. So, because only two circumstances. One, if will is made in Mumbai, and another is if it is in the respect of any immovable property in Mumbai, only then will is necessary. Then probate is necessary. Otherwise, it's not mandatory. In course of it, when we discuss later on, we'll discuss more on that. Okay. Oh, I think I have not made this. Okay. Sorry. Now that slide, I think I have not made. So when person dies without making a will, what are the options a person has got? His legal heirs. Number one is letters of administration without will. Number two is succession certificate if it is in respect of movable property. I mean, so bank account. It could be share certificate. If the assets are that, then it could be in respect of only limited to that, means movable property, because the bank account, share certificate of the company, all those things. And third option which the person has got is Heirship Certificate under Bombay Regulation Act. So what are the options available for a person who dies without making a will? What is legal heirs got option? Number one, letters of administration without will. Number two, if it is only in respect of movable property like bank account, FD, share certificate, it is this thing, succession certificate. And number three is Heirship Certificate. We will go more into detail of what is the procedure for that. So up to now, it's clear. Type LC. LC means of letters of, sorry, LA. Type LA, letters of administration. So that I will understand how active you are. So type LA if you understood in the chat box. Good, Ketan, good Girish, Deepan, Prashant, thank you. Good. Prajakta, Amit, Bharat Bhai. Yes, thank you. Thank you, Banu. Ritesh, thank you. Yes. So your option, letters of administration without will, succession certificate, or this thing, heirship certificate. So I will be taking you through whole of Bombay Regulation Act also. So now it is this. Now next comes is, this is already there. Then what is the process which is required to be obtained for letters of probate or letters of administration with will, without will, or succession certificate? Process for all the things, all these applications, to obtaining all these applications are same. Basically, when you are doing, anyone is doing, making an application for letters of administration or probate, process is same. Only thing is the contents of those applications differs. So first is that you will find there are formats which is prescribed in the rule of Bombay High Court original side for all these applications. Rule number 90, it starts with rule number 97. I'll be putting all those things. We are forming a separate group for those people who are attending this webinar. My team is just collecting this data also of the all attendees. So don't worry about that. Those who are attended this webinar will get all those format also. Or those don't do attend, they will get it directly, can go on the website of the Bombay High Court and check it out. So you will find a particular format is given. We'll go through that format also. The first part is that he has to make an application for petition. You have to file a petition under in a testamentary jurisdiction of the Bombay High Court original side for issue of a probate. Probate or letters of administration or succession certificate. Succession certificate is in respect of particular asset only, not in respect of general. But when letter of administration is granted, it will be either granted, it depends on prayer, restricting to the state of Maharashtra or whole of India. So you will have to have that clarity while making your application in the High Court. The process is that you make an application, and then when you make an application, thereafter court will issue a public notice, or it is also called a citation also, and the copy of citation is also pasted in the High Court, and the public notice also has to be published in the newspaper, and notice also is given to all heirs and next to kin of the deceased in the petition, except those whose consent has been obtained. Now, what is that? What does it mean? It means that suppose a person has died making a will, and he had 4 sons, and he has distributed his property. I'm not going right now what he has distributed, whom he has given. So basically, who are the people who are interested or next to kin, next of kin of the deceased are his 4 sons. I'm just referring to 4 sons. Nothing against the gender, means I'm not referring daughter or something. They are also equally entitled. But for my discussion, I'm using the sons. So what happens? You can, along with that petition, those 2 sons might have filed a consent that the will is proper and they are accepting it. But 2 sons have not filed it. So notice has to be given to those 2 sons also that this petition is filed. when this petition is filed and when this notice they receive, citation, in that case, within 14 days, they have to file a caveat. Within 14 days, they have to file a caveat. Caveat, that is one caveat which we know under Code of Civil Procedure. It's, as an advocate, we know that no order should be passed within without giving me notice of 48 hours is our normal caveat. I think it is section 148A, I believe, or 148 CPC. This caveat is a different. This caveat is a person is filed by a person who has interest in that probate. Basically, court is what asking in the citation is that we'll share that citation also. We'll discuss. Is informing the person that XYZ person has filed a petition in the court, whether you have any objection for grant of probate or letters of administration or succession certificate. So basically what court is asking you, because you are a legal heir, so court is asking you whether you have any objection for me to grant these letters of probate or letters of administration. That court is asking that person whether you have objection. Right. So when he receives such kind of notice or citation, or he comes to know about from the newspaper, but notice is hair, legal hair, which are known person, for them it is mandatory you have to give a notice. Otherwise, again he can make an application for revocation of the probate or letter of administration. When he receives a notice, then within 14 days, he has to file a caveat. After that, after filing a caveat, he passed that no order should be passed within hearing him. That is what the format of the caveat, that no order should be passed without hearing him. Then within 8 days from that, within 8 days from the filing of the caveat, he has to file an affidavit supporting his caveat. That means what? That means he has to file an affidavit stating why probate should not be granted. So he will have to make out his case X, Y, Z, maybe false or what, then court will ultimately decide whether it is, what is it. So moment a person files a caveat or affidavit in support of caveat, this petition is converted into an ordinary suit. It becomes a suit, and then it will become a suit, and things will be like ordinary civil proceeding. And your petition will be treated as a plaint, and affidavit in support will be treated as a written statement. So it becomes an ordinary suit. Then whatever means, I mean to say, then for trial, then the matter will go for trial. Then you will have to produce the witnesses who have seen the who are the witnesses to the will. So it will become like a normal trial where you will have to prove that the will was executed. There were 2 witnesses, the will. So those aspects will have to be proved. Only thereafter, court will give you grant a probate or letter of administration with will or letter of administration without will. So basically, when there is a affidavit filed in support of caveat, it becomes an ordinary suit, and that time you will have to prove. If there is no caveat or no no caveat and no affidavit in support, in that case, court will grant you probate or letters of administration with the will annexed. If it is filed, it becomes a triable court and it is treated as a suit. Is it clear up to now? Any questions? Any questions? Rakesh, any questions are there?
Yes,
What
there are
is
certain
Bharat, what is the
questions in the
question?
chat box.
What is the question from him?
Whom, sir?
Bharat, who will issue notice to legal or the concerned honorable court or the administration? Bharat bhai. Notice will go from the court itself. There's a format of the notice that I will share with you. Notice will go from the court itself. It is not. But normally court itself is not. We have to, as a petitioner, as petitioner advocate, has to facilitate the issue of notice. Okay.
I think there are questions about the jurisdiction for probate.
What is the question? Can you read?
There's one question from Tushar. What is jurisdiction for probate if deceased have property in more than one district or state?
The moment someone is making voice, I can you all of you mute yourself? Jurisdiction is where if property is there in Mumbai and somewhere else, that means property is in Mumbai. In that case, you will require a probate. You have no choice. Probate is mandatory. Whether one part or anything is there, moment something is there in Mumbai, you will require a probate. Okay. Now, what is the question? One, if person wants to file a caveat, but he is in US, then what is the procedure? In that case, he will have to give someone power of attorney to file over here. Otherwise, it's not possible. You will have to authorize someone to do it. Or means I don't know, that possibilities will have to check. Someone will have to file the caveat informing XYZ within what time it's going to happen, or you will have to file a notice of motion, not notice of someone, chamber summon that someone else should be permitted. So it will depend upon facts of the case why he can't file within the particular period. When it is converted to the suit, Dr. Sanjay, it is converted to suit the moment you file affidavit in support of your caveat. Then it will be automatically converted in a suit. You can try your luck, someone files for discharge of a caveat because it affidavit in support does not disclose any cause of action or it does not disclose anything karke, because affidavit can be also 4-liner also. I don't admit the correctness or something like that. So you can take a chance in that case. And steps if no caveat is filed. If no Chirag, if no caveat is filed, that means there is no opposition to the grant of probate. Then after following the procedure, cross verification, proto notary will have to, I am talking about High Court, proto notary will have to give a certificate, there is no opposition, no one has filed a caveat. In that case, court will issue a probate. Then Dhiren Gada, if caveat is not filed but other beneficiaries not beneficiaries objection, then what would be the scenario? If caveat is not filed, other beneficiaries objection. No, for objection you have to file a caveat, otherwise it will be presumed that you have no objection. Or in that case, if probate is granted, then you will have to challenge that, stating that it was obtained without giving a notice. So it will depend upon the case-to-case basis. Is will has to be registered. Prashant, will is not required to be registered. There is no provision which requires will as a mandatory registration. Will is not required to be registration. Will doesn't have to be on the any stamp paper. Nothing is required except there has to be two witnesses. I am talking about unprivileged will. Privileged will rules are different. But now at present we are discussing on the privileged will. So there is no registration required on except two attested witnesses. Nothing is required in the will. Yeah, heirship certificate I am going to. Technically, Amit, you are asking who can oppose the will. Person who has some interest in the property, he will have to make out a case how he is interested in the property. Suppose someone files a probate, even I cannot file a caveat and oppose that will unless we are able to show something into it. Yeah, Geeta, I will share this. Don't worry. I am not sharing because I am not so happy with this quality of my PPT. That's the reason I'm bit avoiding that. Not to my satisfaction, but I will share this time. I can see 85 people are there. We will form a separate group for these people. And Rakesh is keeping a watch on all the attendees. For them, it will be allowed. Sorry. Coming to that, anybody, Tom, Dick, and Harry cannot oppose it. Some person having some interest, he will have to make out a case by filing a caveat. Otherwise, suppose a person who on the street comes and files a caveat and also thereafter file affidavit in support of caveat. That time, technically, it has to be converted to a suit, and then a petitioner can take out a chamber summons for discharge of the caveat. He can take it out, but again, it will depend case to case basis. No, Girish, third party, how they are related, how they will be concerned. They cannot file any opposition to the will. Unless there is some issue which for that purpose. So I means in generally they cannot. See, Chirag, it has to be filed within 14 days. Suppose for some XYZ reason, then you will have to take out an application or chamber summons is a normal process for permitting you to file a caveat and affidavit in support of your caveat. Kiran, if a will is made outside Mumbai jurisdiction and legal are unaware of it, how will the procedure go if other legal heirs are not informed about it? I'm not little bit understanding about it, but if it's outside Mumbai, see, mandatory provision comes if will is made in Mumbai. So if you are not aware of the will, then there is a question goes. So there is no question whether it is. But if his property is in Mumbai, in that case, you will have to file letters of administration without will. Legal heirs, see, suppose it is mandatory that notice has to be given to all legal heir and next of kin. If it is not given, an order is obtained by the petitioner by suppressing the true facts. In that case, he will have to file a chamber summons or notice of motion, whatever the proceeding will be, to set aside or revoke the probate which is granted or letter of administration. So court, after going to your contents of this, will revoke the probate or letters of administration or succession certificate. Bharat bhai, except two witnesses, it must be that a qualified doctor must give a record statement that person who has signed the will is good enough. Mandatory, it is nothing required. Mandatory, Bharat, only requirement is that there has to be 2 witnesses. What happens is often we take one person as a witness, as a doctor, because so that there is on the record that will was made. What are the requirement of the will? That the person should be of sound mind when he is making the will. Otherwise, normally you will find in the court opposition or objection to the will is on the point that the person who made a will was of unsound mind and he had no mental capacity to make a will. That is the reason why he should be, why will should not be granted or why will should not be accepted. That is the main opposition to the will. So if that is so, that is the reason to protect from that. That is a person why he is either a doctor certificate is attached to the will, or if he is ready to become a witness, then well and good. Okay. Caveatable interest. Yes, Chandrakant. Is original will need for, yes, original will, even if, yeah, good that question, Saloni, appreciate that. Is original will needed for proceeding? Not necessarily. There are a provision which if will is not available, will is some part of will is missing, of your a copy is there, then for limited purpose also will can be granted. There is a clear-cut provision in the Indian Succession Act. It can be granted, but then it will be for limited period, for limited circumstances. It depends on what is the reason why you don't have original will. So lot many things will come in that. Wangankar, when executor not giving time for converted suit, then beneficiary plead. When executor not giving time for converted suit, then beneficiary can plead to become a party. No, I am not getting this part, Wangankar. Executor not giving time. See, it is not with executor. Executor has to make an application or probate petition, file a petition for probate. Then things move, and now it is not in his hand. As per required, 14 days notice has to be given. Okay. Sanjay Kulkarni seems to have raised his hand. You want to ask something, Sanjay? You can unmute yourself and ask. Sanjay? Okay, I will proceed. Hitesh is asking, if a process of probate is cumbersome and expensive, could you please suggest some step to be taken by the citizen that will still allow to make succession easier for the next generation after that? See, when a person dies, there has to be something to show that these persons are the legal heirs. So there is actually process are simple as usual. Courts and we know how to make things complicated. According to me, our proper procedure is followed and expeditiously it works out. Within 3 months also things can be worked out. But what happens if there is opposition? Someone is saying no, will is fabricated, or the person who made a will had no mental capacity. That will have to be decided by some person, by the court. So that process will be having, the moment these things happen, it is getting converted into the suit. So there is no shortcut as such. You can make a nomination and all those things, but again the nominee will have a limited interest that he becomes a trustee of the person who are entitled for that property. Okay. Any limitation for period of applying for a will or letter of? See, Saloni, limitation is not as such, but moment you are filing it after 3 years, you will have to give an explanation why there is a delay for that. That will be required to be done. So you will have to give an explanation why you are coming after 3 years, what had happened. So if it was not available, will was not traceable, what is the reason? You have to give that reason. But as such, there is strictly speaking no limitation period as such, but you have to give an explanation. Suppose private trust US made an immovable property is included, will that whether it will be mandatory to register? Will again I am coming to that. Coming to that, will is something which comes into picture after a death of a person. If a trust is created by way of will, it will become an executor's duty to register that will. So nothing comes into picture, if anything is created by will till the person is alive. The moment he dies, will becomes operational. Suppose your example which you are taking, Hitesh, is a person, he has made a will during his lifetime. Tomorrow it's quite possible that he will change his mind. So whatever things are going to happen after his death, if it is something has to be happen on the basis of will. Is it clear, Hitesh? Dhiren, technically it cannot be made. Moment there is a will which is made in Mumbai, it requires a probate. Though property might be outside. Section, you can go through the language of section 57. It's very clear that if the will is made or in Mumbai or it is in the respect of any property which is in Mumbai, that is the two circumstances will has to be probated. Is not obtained and flat situated in the Mumbai is transferred to the nominee. Is the transfer valid? Not any chance of objection can be filed. Technically, Gargi, you will find now there is an amendment to the Cooperative Society Act. I think section 14A, chapter 14A, if my recollection is not wrong, is the new chapter which is added, which deals with the aspect of Housing Cooperative Society Act, and that is a provision. Then that chapter is applicable to only cooperative housing society, and they have included in that some of the provisions of parent cooperative society act, and some have been deleted which will not be applicable. The section of that exact section I'm not recollecting now, somewhere on I think 154.14 or something like that, is very clearly states that either you have to obtain letter of succession or heirship certificate or probate. So you will have to follow that step. To certain extent it has created certain complication, or that you will have to follow. And then there is a word provisional membership can be given to the person who claims to the legal heir of the or the nominee. So there is no shortcut. Thanks, Bharat Bhai. What if witness dies before the execution of will? See, moment you say the witness is deceased, then it will depend case to case basis why will is proper. Maybe some other manners, maybe handwriting expert, or different means you will have to prove that will. But will have to be proved. If will is the end of the day as a document where the Evidence Act will be applicable to proving of the will. Oh, it's 8:20. Yes, I explained already limitation for filing application for probate. There is no limitation, but as I explained, Girish, can witness record video of their statement in support of will? Yes, it can be done, but again, you understand the video recording is more difficult to prove when we consider our Evidence Act into the, because someone will say it has been doctored video or many things come up. So my experience is it is more difficult to prove. Document is more easier to prove rather any video recording. Okay, Vaingankar, I want to ask that executor is not interested in continue with the suit lingering the matter. Other benefit is facing a problem. Executor can be is facing what is it? Executor be removed even though she is one of the beneficiary. Yes, other beneficiaries can continue as for a letters of then it will become a letter of administration. Can register will be challenged in the yes. Registration is not something going to give a big advantage. It can be challenged. Aditya. What if witness die before the execution of will? Then it will have to prove according to yes. Thanks, Amit. 154 is yes. Thanks, Sanjay. 154 be 13. Yes. Thanks. After filing a caveat, Lakshmanan, after filing a caveat transfer into suit, what is the limitation to file a counter claim? There is nothing called it becomes a suit. So how can there be something counter claim? Counter claim is supposed to be normally with the return statement. It becomes an ordinary thing. Then you can file a counter claim. But what is a counter claim? Is there nothing called counter claim? The scope of that suit is going to be very limited. Whether if it's a probate, whether there is a will or not, if it's a will proved or not. So there cannot be something called counter claim in this suit. So the limited scope of this kind of suit is very limited. Is it Naga? I don't know what is the meaning. Is it in Naga or I'm not understanding, Mohit. Can an executor become a facial? That is again this thing, yes. This is a testamentary matter. So in both parties want to settle. Yes, they can settle. Tushar, check up what is what is the privilege will in the Indian Succession Act when a soldier is at war or other circumstances which they are given when will can be executed. Yes, Akshay, Akash, it can be settled by filing a consent term. It will again depend. The moment you file, it becomes a suit. So in that you can always file a consent term. Moment you file a caveat. If a person had non-movable property and bank balance, so what I will do is that I will stop here taking this question and I will move towards the Heirship certificate. Don't worry. After that we will take it because someone of you might have want to leave it. So just Rakesh, we have come up to the Mohit asking a question if flat is in Nagav or Palghar. We'll start our this thing afterwards. Continue our this thing chat afterwards. We'll go proceeding further because it's already 8:25. See, normally I find that is something called Heirship certificate, which often comes into the picture. Heirship certificate is very old act, now nearly 2 centuries old act. What it talk about is basically it is not necessary to get yourself as a recognized as a legal representative of the estate of the deceased. There is no formal recognition required from the court. Section 1 of that. But Section 2 and 3 says that if you want a formal recognition that a concerned person is a legal representative or the legal heir of the person who died, in that case, you have to make an application to the district court. The word used in that provision is Jilla Court. Just hold on, let me know. Is Jilla Court. So you have to make an application. It's more or less like same what we discussed in obtaining probate also. You have to make an application to the court, district court. Then district court will issue a notices. One notice has to be published in the newspaper and other notice and one is citation. the same process which is followed. And citation is one copy is pasted in the court where no one looks at it, and other copy which is posted is the, if there is a property mentioned in that case it will be pasted at the property also, and two witnesses goes with the bailiff. And to the citation, if there is any objection, basically citation means what, or public notice is what, that I will share maybe one public notice with you, is basically what is petitioner has made an application for issue of heirship certificate. Anyone having any objection to that should make known to the court, and when any person has an objection to that procedure, it is not elaborately as stated in this, is he has to file an affidavit to that. The moment a person files an affidavit to that, just the court will consider from what is stated in the affidavit whether after summary investigation, whether further investigation is required or not. It will depend on case to case basis, and if it is not required, summarily court can also decide that issue. But if court feels no, it requires some complex issue to be decided, then in that case court may say file a separate suit and dismiss the application also, or court from examining the content of whatever is filed feel that this is not a frivolous objection which is taken. In that case, grant a heirship certificate also. So it will basically depend when a person makes an opposition to the heirship certificate, whether he has got a genuine interest in opposing such application or just a frivolous application which is made. If it's something complex, then court will say go and file a separate suit, or court itself can decide that issue. So there is no hard and fast suit. Not regular suit. Okay. Then when a same thing, because this is of 1827, if it's a will on which basis of heirship certificate is filed, then there was no term as called probate in those days. So it was called heirship certificate only. And then when it is recognized, then is recognized as a legal heir of a person, as an executor, then all proceeding will continue like that, continue as of our now at present Indian Succession Act. But again, understand here, section 7 says that if a person has an interest in the property, it will not mean that his rights are defeated. Like in Indian Succession Act also, you can always file an application for annulment, it is what is called in the district court, that heirship certificate was wrongly issued, process was not followed, he had not received notice, whatever the reason might be, XYZ issue can be taken. So it is not something which is a final. If there is opposition, you can always thereafter also file an application for setting aside that order of heirship certificate. Again, section 8 again comes to that. A refusal to give a heirship does not mean that the person has no right in that property or the being heir, but then he will have to establish by filing it not a normal suit. So that is a difference which is made in heirship certificate. Basically, this is an act which is 200-year old, but again now it has been modified in I think 2012. So there are I think some amendment has taken place, but basically it's the same procedure which is to be followed as that of which we discussed for probate or letters sorry, not letters patent, letters of administration. Same process, public notice, hear the objection, then decide. Only thing is that if we see Bombay High Court rule, it is more elaborate. And unfortunately, I tried finding in civil manual, which is applicable to the district court, no such elaborate process has been prescribed for that. Okay. So this is what basically was, sorry. This is what basically was on the probate and on the discussion on probate letters of administration. So now whatever query is there, furthermore query is there, if it is there, we will go ahead and check what is the query. As per my knowledge, the joint will is not allowed in India. Sanjay, it is a debatable question. But we discussed this issue on last time in the will part. I don't want to open that Pandora box now here. Lakshman, have a peculiar matter. Husband is Hindu and wife is Christian. Both die in a quick succession. First husband and then wife. Without any will and without any children relative. Without any children. Okay. Relative of Hindu. Have a paper. Husband is a Hindu. Husband is the moment you are saying husband is a Hindu, when his property comes into picture, Hindu Succession Act will be applicable for that. Relative of Hindu file a letter under the Hindu Succession Act, right? Relative of wife file a caveat opposing, saying that wife so that it should be an Indian Succession Act, which should be ground to decide a succession, how is transferred to. Now it is transfer source. So what the procedure will further? The moment Lakshmanan, moment it is transferred to suit, then on basis, what are the basis, what succession act will be applicable, that court will decide it. Honestly speaking, that's a good question, new issue which is there, I can see. And I think will require a further understanding of that, this thing. Maybe more research will be required to be done on that. But prima facie, when a Hindu dies, Hindu Succession Act will come into picture. Then I don't recollect anything in the provision, at least right prima facie, I don't recollect anything in Hindu Succession Act that if wife is a Christian only then property, if wife is a Hindu only then property should be given to the wife. I don't recollect, I am just being candid enough. If he is a Hindu, he dies, and if wife is entitled to property, then she becomes entitled to that property. But moment you are saying, so she becomes, suppose, taking your question, Lakshmanan, that a person died, he was a Hindu, and for our discussion, let's say only he had a wife and one son. So wife and son both become entitled for the flat moment he dies. As per Succession Act, both are entitled to. Moment wife dies, it will be her share will be governed as per the Indian Succession Act. So that is same procedure according to me. On the face of it will have to be followed. But if further probing is required, I don't know. I can't speak it right now. Is it okay? Have you followed? Now, what is the difference between heirship certificate and letters of administration? See, heirship certificate is technically a declaration that particular person is a heir of a deceased. even letters of administration is more or less, it's also same thing, because letters of administration under section 218 can be only given to the legal heir of the deceased. So basically, same provision, same conceptually rule is applicable, that it is given to the legal heirs of the deceased. But heirship certificate being processed under the Bombay Regulation Act, so it is declaring basically as a heir of the deceased. Format of the certificate is a different. Mangesh, okay. Yogesh Shankar. If no will, family registered deed is valid, or heirship certificate. It depends upon what is the factual situation, Yogesh. If it's a deceased person's property has to be distributed, it has to be distributed as per Indian Succession Act only, or Hindu Succession Act, whatever is applicable. Thanks, Manav. Thanks, Irene. What jurisdiction for filing release deed? What property is located? What is? I don't think it is related to this issue, Ravindra. Wherever the property is situated, if you are opposing filing release deed, I don't know why release deed has to be filed. What property or where person residing? Hindu Succession Act is applicable to only HUF in individual Hindu succession. Hindu Succession Act is applicable to Hindu, nothing for HUF as such. It will be applicable to individual only. Have a peculiar matter husband. Again, it is coming or what? For I didn't. Living will, Bharat Bhai, I have not studied much on that aspect. Living will basically is during your lifetime. My study is limited on that. Is a lifetime. He is telling this property should be gone to will. That's what my recollection. I think this recently, few days back, that issue was started. So I have my limited knowledge on that. Basically, he wants to die because of the disease which he is suffering to, which is incurable. So he should be permitted. That's what my recollection. But I am not able to, won't be able to speak much on it now. Thanks for asking. It's a good question. I will check up for my own knowledge, not for webinar. I think that judgment, that issue, I think around few months ago had come. Yes, Ravindra, court fees has to be made. Good that question you asked. Court fees for probate petition, it depends upon the probate or letter of administration, depends upon the value of the property. And it is 1/4 of normal suit. Suppose maximum court fees, suppose a court fees for a particular asset which is there comes, suppose 1 lakh rupees for a normal suit. But if it's under testamentary jurisdiction, you will have to pay 1/4 of it. That means 25,000. Court fees is applicable for any proceeding under testamentary jurisdiction. Yes, thank you. Anything more? It's already 8:40. I think if any topic is missed, only one thing is that when is succession certificate is this thing is prayed for. Succession certificate is only when I will stop sharing this thing. Succession certificate comes into picture only when there is immovable property is involved. Okay. Any further questions? Someone wants to ask, unmute and ask question. They can ask the question. I forgot one thing. I request everyone to give me a proper testimonial on the group chat. And other thing which I wanted to request you is that subscribe to my YouTube channel. I will put one more video of that YouTube channel. And so kindly subscribe that, so that it's more encouragement for me to conduct such kind of webinars, and also make some videos on various topics. So kindly give your testimonial on the group, and other, as promised, those people who have attended this webinar, for them, one is that all those relevant provisions of the Bombay original site rule I will put in that group. A separate group will be forming just in next few minutes, and all of you join that group. I will put in this thing. From that we'll sort out who have not appeared and we'll remove that and join to that group, which the link I will provide. I'll provide
So
various
can
judgment on the
you
different
post
topics.
the
Yeah.
link for joining WhatsApp group here in the chat box so that everybody who is present can join immediately?
Yes. You have that link.
I think you are admin, so I will not be able to share the link.
Okay.
Right.
Just a minute. 8 minutes. 8 minutes. 8 minutes, Rakesh? No, I will, yeah, 8 minutes. Yeah, someone want to ask question? Or we'll put in the group. Okay, no, wait, just hold on. We'll put here. Just hold on. I'm making which group? Wait a minute, huh? No, rather we'll put there only. Mentorship. No, Rakesh, I don't have that link now.
Okay.
No, I think this is, yeah, this link I can put. Yeah, we'll put this link. Just a minute. Just a minute. I'm putting a link on this group and not this. Just a minute. Give me a second. Give me a second. I'm just putting a group link. Join to this. No, I'm not able to. Yeah, I have put a link, chat box, WhatsApp link in that. Kindly join that group, and so that I will post. It is not. No, 8 minutes. 8 minutes. Just a minute. I don't know why it is. Eight minutes. It has gone only to one person, I believe. Right. Rakesh has put the link. Join that link.
Yeah, just
the
try
WhatsApp
and
group.
join. If you're not able to join, then you will have to then send in the group.
Okay. Thank you, everyone. Thank you for attending this webinar. I hope you understood whatever I wanted to convey. If you have any question, you can ask your question on the group also. Okay. Thank you. Bye-bye. Good night. Bye. I'm keeping this meeting open for some time so that you can copy that chat. Sure. I'm stopping here. Bye bye. Thank you. Good night.